The hearing was scheduled for 9 o'clock on a Thursday morning, and by 8:55, the gallery was full. Word had moved through the legal community the way word moves in small professional circles, where everyone knows everyone, and the stakes of everyone else's business are everyone else's business. Camille Okafor, one of the city's sharpest civil rights attorneys, was going to have her license suspended. The complaint against her alleged that she had falsified client intake documentation in 4 cases over 2 years, fabricated dates, forged authorization signatures, submitted altered contracts to the bar's disciplinary committee as authentic. If proven, it was the kind of violation that ended careers, not suspended, ended. The bar's investigative officer had reviewed the documentation and found discrepancies. A senior partner at the firm where Camille had once worked had provided the allegedly authentic originals for comparison. The partner's name was Geoffrey Marsh. He had known Camille for 11 years. He had been her supervisor for 3 of them, her competitor for the remaining 8, and the man who had in those 8 years lost to her in court so many times and in such precisely documented ways that his reputation had developed a specific texture. Not incompetent, never incompetent, but reliably second to one particular attorney on one particular type of case, in a city where that distinction followed a person into every room. A had submitted the complaint in September. He had provided the comparison documents in October. A had arrived at the hearing that Thursday morning in a charcoal suit and an expression that suggested a man preparing to watch something he had been waiting a long time to see. What he had not prepared for was Camille Okafor, seated at the respondent's table with her hands folded and her original documents, the actual originals, dated, witnessed, and secured in a fireproof lockbox since the day each one was signed, arranged in a neat stack in front of her. She had not told Geoffrey Marsh she had them. She had not told the bar's investigative officer. She had not told anyone because she had learned in 11 years of practice that the most powerful position in any proceeding is the one that knows exactly what the other side believes you don't have. She had let the hearing be scheduled. She had let the complaint proceed. She had sat with the full weight of what was being done to her, and she had not flinched, and she had not tipped her hand. And now it was 9 o'clock on a Thursday morning, and Geoffrey Marsh was about to find out what it costs to forge a document in the presence of the woman who holds the real one. 12 years earlier, Camille Okafor had passed the bar on her first attempt with a score that placed her in the 91st percentile statewide. Anne had accepted a position as an associate attorney at Marsh & Holliday, one of the city's mid-sized general practice firms, because it was the best offer she received and she intended to make it count. She was 28 years old, the daughter of a Nigerian-born cardiologist and a Jamaican-born secondary school principal, who had between them accumulated 4 advanced degrees and an absolute intolerance for the idea that effort and preparation could be outcompeted by anything other than superior effort and preparation. This had produced in Camille a quality that her law school professors had variously described as tenacity, relentless, and, in one memorable evaluation, a capacity for argument that bordered on the physically uncomfortable to oppose. She took this as professional guidance. She had grown up in a household where Sunday dinners were also seminars. Her father would pose a medical ethics scenario. Her mother would pose a policy contradiction. And the children were expected to argue positions they didn't hold and defend them rigorously, because the point was not to win, but to understand the structure of an argument from the inside. Camille had been doing this since she was 9 years old. By the time she walked into a courtroom for the first time, she had been preparing for it, in some meaningful sense, for 19 years. Marsh & Holliday put her in civil litigation. Not her first choice. She wanted civil rights work, but the firm did not have a civil rights practice, and she had decided, at 28, that the technical training was worth the detour. She learned discovery procedure, motion practice, deposition technique, the specific architecture of how evidence was built and challenged and dismantled. She learned from the good lawyers and the mediocre ones, which was more instructive because watching someone do something badly is a faster education in what good looks like. She billed more hours in her first year than anyone had in that associate class in a decade. She won cases she had been told to settle. Geoffrey Marsh was 44 years old when Camille joined the firm. a NAMIT partner with a specialty in employment litigation, and a practice built on a particular combination of intellectual confidence and institutional ease. The kind of lawyer who moves through the machinery of the legal system the way someone moves through their own house in the dark. He had grown up with money, attended the right schools, joined the right firm, made partner on the expected schedule. He was not a bad lawyer. It was a very good one. What he had never developed, because he had never needed to, was the particular resilience of a lawyer who had been underestimated and had learned to use the underestimation. He noticed Camille in her first month with the attentiveness of someone who has recognized a competitive threat before they can name it. He was generous with his advice. He was less generous with his referrals. And he paid close attention to the gap between those two things, because it was professionally useful to keep a junior attorney grateful without allowing them to become formidable. Camille became formidable anyway. In her third year, she began taking pro bono civil rights cases on the side: employment discrimination, housing complaints, police misconduct claims, filing them herself after hours, building what would eventually become her own practice before she knew that was what she was building. She won her first civil rights case against a municipal employer in her fourth year. The ruling was cited in two subsequent decisions. Jeffrey Marsh read the citation and said nothing to her about it, which told her more than congratulations would have. She left the firm at the end of her fifth year and opened her own practice with one associate, a borrowed conference room, and a client list that materialized faster than she had projected, because in 5 years she had built, without quite intending to, a reputation for taking the cases that other attorneys assessed as unwinnable and winning them with a thoroughness that made the judgment seem naive in retrospect. Her departure was cordial. Her competition was immediate. She and Jeffrey Marsh found themselves on opposite sides of the same case type repeatedly, because civil rights and employment litigation overlapped in specific ways, and the city was not so large that two specialists in adjacent areas didn't eventually occupy the same courtrooms. She won more than she lost against him. Not all, more. This went on for 8 years. In the 8th year, she prevailed in the Henderson case, a wrongful termination claim against a major employer that Marsh had represented. That had been expected to settle, that went to trial, because Camille had advised her client that the documentary evidence warranted it. And that resulted in a jury verdict that was covered in the local business press as a significant loss for the defendant. The coverage was not extensive, but it named Marsh's firm, and the client, that had been expected to remain on the basis of the Henderson outcome, did not. Camille knew none of this. She knew she had won the case on the merits. She went home that evening and told her husband Kofi about the verdict, and he opened a bottle of wine they'd been saving. And she called her mother, and her mother made a sound that Camille had been trying to earn her whole life. And she went to bed and slept without difficulty, because the work had been done completely, and the outcome reflected that. She did not think about Jeffrey Marsh. She had a new case brief to start in the morning. The complaint was filed 11 months after Henderson. Camille received notification from the bar's disciplinary committee on a Monday afternoon in a letter she read standing in her office doorway, because she had opened it without sitting down. The allegations were specific: 4 client intake files, 2 from her early independent practice, and 2 from the Henderson era, allegedly contained documentation with fabricated dates, forged client signatures, and altered contract language, alterations that had not been present in the originals as held by the firm during her tenure. The originals, the letter explained, had been provided by Jeffrey Marsh, who had retained copies of client files from her time at the firm as a matter of routine record-keeping. She sat down. She read the letter a second time. She read it with the particular attention of a lawyer reading a legal document, not for the surface meaning, but for the architecture, the specific word choices, the evidentiary structure being implied. She was looking for the mechanism, the way it had been built. The complaint relied on comparison, her submitted documents against Marsh's allegedly authentic originals. Comparison cases had a specific vulnerability. They required the challenger's documents to be genuine. If his weren't, the entire structure inverted. She thought about the files in question. 4 of them, 2 from her early independent practice, 2 from the Henderson era. She thought about the features of original documents that copies could not fully replicate: the pressure of a wet signature, the specific indentation of a notary seal. The paper stock she had used in those years, sourced from a single supplier whose watermark ran in a consistent diagonal she had noticed and never mentioned to anyone because it had not been relevant until now. She thought about what Marsh had access to. He had copies she had provided as exhibits in the ordinary course of litigation, the standard practice of any active case file. Copies were photographs of a document. They were not the document, and within 20 minutes of sitting down with the letter, she understood that he had tried to build the accusation out of photographs while she had been sitting on the architecture the whole time. He had built the forgeries from copies. She had the originals. She did not call the bar's investigative officer. She did not call Marsh. She did not call anyone in the legal community who might inadvertently signal to him what she knew. She called her husband and told him what had happened. And there was a silence on the phone that carried the specific weight of a person absorbing news that is terrible and that they are deciding in real time how to hold. Kofi asked what she needed. She told him. He said he would handle it. She made one more call, to Adela Vance, the forensic document examiner she had used in 3 prior cases, who could authenticate originals and identify alterations with the precision that courts required. Then she opened her lockbox. She had kept the originals in a fireproof lockbox since the first week of independent practice, because she had learned from a senior attorney early in her career that the document you need most is always the one you didn't think to keep. She had not kept them in anticipation of Jeffrey Marsh. She had kept them because documents were the architecture of her work, and she treated them with the same care she treated any load-bearing structure. She pulled the 4 files in question. She reviewed each one. Every signature was original. Every date was authentic. Every piece of paper was exactly what it had always been. She put them back in the lockbox and went to bed. The bar's investigation took 3 months. Camille cooperated fully, providing responses to every inquiry, requesting at each stage only that the procedural timeline be honored, which it was. She did not retain outside counsel to represent her in the disciplinary proceedings, because she was outside counsel and she was better at this than anyone she would have hired. She prepared her response to the complaint with the specificity she brought to every case, each allegation addressed, each document cross-referenced, each forgery's mechanism identified and annotated. She had Adela Vance examine all 4 originals and produce a forensic report comparing them to the documents Marsh had submitted. The report was 18 pages. It identified, in each of the 4 alleged forgeries, specific markers that distinguished them from the originals, toner distribution patterns consistent with high-resolution scanning and reprinting, micro-variations in signature, reproductions indicating digital interpolation, paper stock inconsistencies, traceable to a commercial print run from a date after the documents were allegedly created. She also sent a letter to the bar's investigative officer, not as evidence, not yet, but as procedural preparation, noting that if the comparison documents submitted by Jeffrey Marsh were determined to be inauthentic, the submission of forged documents to a bar disciplinary proceeding constituted a separate and serious professional violation. She noted this once, precisely, without elaboration, and moved on. She did not need to say it twice. She needed it on the record. The hearing convened at 9 o'clock on a Thursday morning. The gallery was full. The bar's hearing officer called the proceeding to order. Marsh's counsel presented the complaint and the comparison documents, walking through the alleged discrepancies with the confident economy of a legal team that expected to win. They were thorough. Camille watched them work and said nothing, and kept her hands folded on the table and thought about Sunday dinners, where the point was never to win, but to understand the argument from the inside. When it was her turn, she stood. She acknowledged the complaint. She acknowledged that discrepancies existed between the documents she had submitted and those provided by Jeffrey Marsh. She then noted that this discrepancy had a precise explanation. The documents Jeffrey Marsh had provided were not the originals. She placed the forensic report on the record. She placed Adela Vance's authentication analysis on the record. She produced the 4 original documents, the actual originals from the lockbox she had never mentioned, and submitted them for comparison by the hearing officer and any expert the committee wished to appoint. The gallery, which had been quiet in the particular way of people preparing to watch a predetermined outcome, became a different kind of quiet. There is a specific silence that a room of lawyers produces when the evidentiary ground shifts beneath a proceeding they believe they understood. It is not the silence of shock. Lawyers do not shock easily, and the good ones are trained to absorb reversals without expression. It is the silence of rapid, simultaneous recalculation. Every person in that gallery was a legal professional, and every legal professional in that gallery understood within 30 seconds what the forensic report and the original documents meant. That the documents submitted by Jeffrey Marsh were not authentic, that he had known they were not authentic, and that he had submitted them to a bar disciplinary hearing anyway. The hearing officer looked at the documents, then at Marsh's counsel, then at the forensic report. The recalculation on his face was brief and total. Marsh's counsel requested a recess. The hearing officer granted 15 minutes. During those 15 minutes, Camille sat at her table and looked at the stack of documents in front of her, and thought about the Monday afternoon she had read the complaint letter standing in her office doorway, and the two readings of it, and the moment she had identified the mechanism. She thought about the 8 years of cases. She thought about Henderson and the bottle of wine, and her mother's sound on the phone. She thought about her father's Sunday dinner ethics scenarios and her mother's policy contradictions, and 19 years of learning to understand an argument from the inside. The recess ended. Marsh's counsel returned to the table with a particular patter of people who have spent 15 minutes understanding what had happened to them. The hearing officer had reviewed the forensic report in summary and requested the appointment of an independent document examiner, which the committee authorized. The independent examiner confirmed Vance's findings within 6 days. Jeffrey Marsh resigned from the bar's employment litigation committee on the following Monday. His firm issued a statement that week describing the matter as involving a misunderstanding of document provenance, a phrases that would appear in legal ethics commentary for the next several years as a specimen of institutional euphemism. The bar opened a separate proceeding against Marsh for submitting fraudulent documents to a disciplinary hearing. It concluded the following spring. His license was suspended for 18 months. His firm, managing the reputational fallout from an episode that had been widely discussed in the local bar community, quietly moved away from the employment litigation practice area over the following year. The complaint against Camille was dismissed in full. No finding of misconduct. The committee's written determination noted that the documentation submitted by the respondent was consistent with authentic originals, and that the complainant's documents were not. It did not use the word forgery in the formal finding, because disciplinary committees choose language with the care of people who understand that language has weight. What it said was sufficient. Camille returned to her office that Thursday afternoon and sat at her desk for the first time since the complaint had arrived, and did something she had not permitted herself to do during the 3 months. The proceeding was active. She let herself feel the full scope of what had been attempted, not the legal exposure which she had addressed methodically and completely. The other thing, the decision that Jeffrey Marsh had made to take 11 years of competition and 8 years of losses and channel them into an attempt to end her career, using the specific mechanisms of the institution she had spent her life building within. The particular coldness of it, the knowledge of what a bar complaint costs a solo practitioner in time, in client confidence, and the specific psychic weight of having your professional integrity formally questioned by the body that governs it. It had known exactly what he was doing. She allowed herself to understand this completely. She sat with it for the amount of time it required. Then she opened the new case file on her desk. A wrongful termination claim, potential class action, strong documentary record. Era Societe had flagged it 2 weeks ago, and she had not had the bandwidth to review it. She had the bandwidth now. She read the brief, she saw the argument. She picked up her pen. The work did not wait. It never had. She was very good at it, and she intended to remain so. Kofi brought dinner to the office that evening because she had not surfaced by 7 and he knew the signs. He set the container on her desk and looked at the case file and said nothing except that the food would get cold. She told him 10 more minutes. He sat in the client chair and waited, because that was the arrangement they had worked out over years. Not that she would stop when he arrived, but that she would not be alone in the room when she remembered to stop. 10 minutos later, she closed the file and turned around, and they ate dinner in her office with the city lights coming on outside the window. And she told him about the moment the gallery went quiet. Annette told her he had never doubted it, and she told him she had, briefly in the 3 months before the hearing. Doubted it in the way you doubt anything when the weight of it is enormous. and the outcome is uncertain, and you're holding the evidence in a lockbox and waiting for the moment to use it. Aside, but you held it. She looked at him. She thought about the lockbox and the originals, and 9 years of keeping documents, because documents are the load-bearing structure of the work, and you treat load-bearing structures with care. She had held it. All of it and all along. That was enough.